Good morning and welcome to our virtual panel discussion. Before handing over to our facilitator, Lebohang Mabidikane, I'd like to run through a few housekeeping matters which will hopefully enhance this webinar experience for all of you. As participants, you are all automatically muted, so should you have any questions during the webinar, please make use of the Q&A tab at the bottom of your screen. Your questions will be submitted to the facilitator, who will select a few to discuss with the panel at an appropriate time during the webinar. 2 points relating to questions. Firstly, written responses to individual questions will unfortunately not be provided. And secondly, please do not pose questions via the chat tab. The panel has prepared a poll, which will appear on your screen shortly after the webinar commences. It will remain open for approximately 20 minutes. And the results will be shared anonymously towards the end of the webinar. Please take a moment to complete it, as it'll be interesting for both the panelists and for you as participants to hear about your respective experiences around competition law compliance during COVID-19. We reiterate that your responses are completely anonymous, even to us as hosts, so please don't let that put you off from participating. Finally, the webinar is being recorded, and a copy will be available on our website later today at www.bowmanslaw.com. At this point, I'd like to introduce you to Lebohang Mabidikane, a partner in our competition team, who will be facilitating this morning's discussion. Over to you, Lebo.
Good morning, everybody. Thank you for taking time out from your very busy lockdown schedules to join our webinar this morning. Welcome. Our webinar is entitled Pricing in a Crisis. As Simon has just indicated, my name is Lebohang Mabidikane. I'm one of the partners in the competition law practice at Bowman's, and I am joined by a highly esteemed panel. I'm going to introduce them one by one. Firstly, we have Heather Irvine. Heather is a colleague of mine and a partner in the competition law practice at Bowman's. And then secondly, we have Phil Alves. Phil is the senior managing consultant at Berkeley Group in South Africa. And then we finally have Professor Mncube. Liberty is a professor of competition economics at Wits University, and he is also the managing director at FTI Consulting in Johannesburg, South Africa. Good morning, everybody. Thank you. Right, so I'm not going to repeat the housekeeping rules. I hope you were all paying attention when Simon explained. Safe to just remind you that we'd really appreciate your participation in the poll. So by way of introduction, in the way of the recent coronavirus outbreak, retailers and pharmaceutical companies have seen a surge in the demand of certain products due to panic buying. While economic theory indicates that high demand drives price increases, it seems even more so when the rapid spread of a virus of this nature sends consumers into panic mode. We've also seen recently the Consumer Goods Council of South Africa urging consumers to lodge complaints with the Competition Commission in the event that they see a surge in prices of goods during this crisis. So from a competition law perspective, the most likely complaint to arise from panic buying is in fact an excessive pricing complaint, which the competition authorities are empowered to regulate in terms of Section 8A of the Competition Act. Pursuant to this provision, the Minister of Trade and Industry has on the 19th of March 2020 issued regulations specifically prohibiting excessive pricing of goods such as toilet paper, sanitizers, hand sanitizers, disinfectants, facial masks, rice, and a whole host of other goods which are deemed to be essential goods at this period in time. And in order for us to, also these regulations are relevant as well to the provisions in the Consumer Protection Act, which prohibit unfair and unconscionable pricing. So we are very privileged this morning to have our panel to help us navigate this whole interesting topic of excessive pricing during the national disaster, what it means, whether it's different from the, the excessive pricing prohibition in the ordinary cause, and exactly what that world looks like. So just to kick off, I'm going to start with you, Heather, and just ask you, how easy do you think it will be from a legal perspective for the Competition Commission to sustain an excessive pricing complaint during this time?
Thanks, Lebo. I think the Commission is going to face some challenges, and that mainly arises from the way in which these prohibitions have come into being. It's important to remember that this particular kind of excessive pricing regulation, which has been introduced for the period of COVID, has come into being by means of a regulation. Now, the Act allows the Minister Patel, to pass this kind of regulation. But of course, any regulation is always subordinate to the legislation which gives it life. And I think that raises three particular challenges from a legal perspective, leaving aside the economic issues that Liberty and Phil are going to talk to us about. The first is, it seems to me that the Minister may have intended this particular kind of excessive pricing restriction to apply incredibly broadly to all suppliers of these essential goods, not only firms who are dominant in their particular markets. There's no mention in the regulation itself of the requirement that a firm be dominant or a supplier be dominant. So it seems to me that that may be a difficulty for the Commission. The regulation can't get around the requirement that is quite clearly stated in the Act, that a supplier must be dominant, otherwise the restriction on excessive pricing doesn't apply at all. Secondly, I don't think that this regulation can change the test for excessive pricing. The Act clearly says that an excessive price is one which is unreasonably above the competitive price. So there is always going to be a debate about what the competitive price is, and hopefully Liberty and Phil can give us some thoughts on that a little bit later. But that remains the legal test for whether there is excessive pricing or not, no matter what this regulation says. And then lastly, it seems to me that the regulation can't get around the other factors that are set out in the legislation. So the section quite clearly says that when an adjudicator considers whether a price is excessive or not, they have to consider all relevant factors. And there are a number of them set out in the Act itself, but then that's not a limited list. Firms can introduce all sorts of other factors that motivated their pricing. And so the reference in the regulation to whether or not you've charged a price which is unrelated to your cost, or which is more than what you've been charging in the preceding 3 months margin-wise, that to me cannot trump what the Act says, which is that an adjudicator has to consider all of the relevant factors when deciding whether or not you've charged a price which is excessive. But this is obviously something which we're just starting to think about. And if anyone has any questions on that or any comments, by all means, feel free to type them into our Q&A section and we'll try and deal with them. Thanks.
Great. So maybe we can ask Liberty. I mean, what Heather's just covered is really the legal implications around whether these complaints can be sustained. But can we maybe hear from you, Liberty, on whether from an economics point of view, these complaints may be sustained?
Thanks, Lebo. And I'll pick up from what Heather has said. I think the first thing to note is that the Commission has some experience in cases involving excessive pricing. Even before the COVID-19 crisis, it had dealt with a number of investigations over the past few years. Notwithstanding the Commission's experience, this is a complex area of competition law, and competition authorities are generally careful on which cases they intervene so that they can avoid over enforcement. But the complexity and the issues of risk in relation to under enforcement or over enforcement cannot be overstated. and should not result in situations where they do not enforce. But in particular, I think intervening now in relation to the COVID-19 crisis is appropriate in some instances. And then the issue is, which are those instances that the Commission must consider? So for instance, where market conditions are such that the high prices being charged for these select goods is unable to stimulate entry and allow the market to properly self-correct in a reasonable time period, that is justification enough. But also there may be circumstances where the excessive price increases in this environment are also, happening in an environment where the costs have remained broadly stable prior to the lockdown period, which raises even more concerns. That said, I think the assessment will not be that easy. It will have to define markets, product and geographic. I would think that the lockdown rules would mean even narrower geographic markets, making it easier for the competition authorities to find dominance in some markets. The immediate period of the COVID-19 crisis restricts travel patterns. And that means that in some specific cases, the restricted travel patterns will mean narrower geographic markets. And here you must also remember that we're talking about cases where the turnover is above 5 million. So we're really talking about cases that meet that threshold test. I agree with Heather that dominance will not be easy, and dominance has to be considered. Presumptively, we think of a dominant firm as being above 45%. But I think we should also acknowledge that a firm with a market share that is less than 35% and which lacks market power is not restricted from charging high prices during this period, because it would not meet the dominance thresholds. But the trick for me comes in the definition of what market power is. The power for a firm to control pricing, to behave independently of competitors, customers, and suppliers. We teach students in competition economics that market power is an issue of degree rather than of existence, because all firms to some extent can behave independently of others. So the key thing here would be that issue of substantial market power. And for the Commission to sustain a case, there may be a few useful screens that one has to consider. A firm has to have significant market power. In a market or a market structure where you have an oligopoly situation, it is less likely that a dominant firm will have such substantial market power to price excessively. But I think the one thing I would like to perhaps emphasize more is that the prohibitions on excessive pricing talk about the Commission making a prima facie case for an excessive price. And the regulations set a lower standard for that prima facie case. For me, I think this is an issue that will be debated in courts ultimately for those contested cases. Because on one hand, it could be considered short-sighted for the Commission to restrict its excessive pricing assessment only to the standard set up in the regulation, to the exclusion of other standards. But on the other hand, I think it will be within the Commission's discretion to choose its approach in determining an excessive price in a particular case, given the available evidence. So to the extent that the Commission is not obliged to consider all other factors if it determines that given the COVID-19 crisis, the standard set in the regulation is the most appropriate. So to the extent that some may say the Commission is compelled to use the standard in the regulation, I disagree, but I think it has a discretion in following and sticking to that standard in some cases. So I do not think the tribunal, though, is bound by the Commission's discretion. So the tribunal will be entitled to find, given the evidence available, what the case is, So to sum up my remarks on this, I think the regulation makes it easier for the Commission to refer a case to the Tribunal for adjudication, but it remains to be seen whether the regulations will make it easier to sustain a case. Each case will require a thorough, case-specific and rigorous analysis for that determination to be finalized. Thanks.
Yeah, that's interesting. I mean, just building up on what you, Liberty, and Heather have said, I just wanted to go back maybe to Heather and just maybe help us think through whether, in light of what both you, Liberty, and you have said, whether prosecution during the national disaster period should really be the ultimate goal for the Commission. In other words, if you look at the fact that the regulation makes no mention of dominance, but you say we should stick with the dominance requirement because that's what the Act requires, do you think that the Commission should really be focusing just on prosecution, or do you think that other measures such as advocacy can really be invoked during this period to try and fast track the cases and try to find some quick resolutions to some of these complaints?
Yeah, I do, Lebo. I think that prioritization is going to be key for the Commission. I have an idea these regulations have probably had a widespread deterrent effect, in the sense that firms may not appreciate that they aren't at risk if they're not dominant, and have therefore constrained their price increases in ways that they wouldn't have done if we hadn't had these regulations. The Commission has indicated that they are prioritizing, so they are focusing particularly on complaints that come from medical professionals and other people who really need to get these products and services. So that's also going to have a limiting effect. And then potentially, I think we might see the Commission engaging with SMMEs, for example, and simply seeking an undertaking that they won't do this again if there have been instances where they have done it. I think they will probably only refer complaints for adjudication where they can find evidence of relatively widespread and substantial price gouging that's gone on more than an occasional basis through this period. And that's probably an efficient use of the Commission's resources.
Yeah, that sounds quite interesting. Maybe we can move to you, Phil. If you can just take us through the excessive pricing assessment, just in a few words. I mean, what is the Commission looking for here to find an excessive pricing as envisaged by the Act?
Thanks, Lebohang. Good morning, everyone. Yeah, I mean, I think the main point here is that we are dealing with what we expect to be short-run price fluctuations, short-run increases in price. I mean, we hope so anyway. And excessive pricing law in South Africa and in Europe is typically built on a long-run notion, not a short-run notion. It is not the case that short-run fluctuations in price, even if they are significant, usually trigger excessive pricing investigations. Excessive pricing is about whether or not a dominant firm can sustain prices that provide what we call excess returns, or returns on capital employed for the product in question, that are above what one might consider to be normal economic profits over a longer period of time. And that may be because entry into that firm's market or into that particular product market is very difficult, and so excess profits cannot be competed away through entry. And there are reasons for that, like patents or other regulatory barriers to entry. And we've seen that in South African case law. The two main cases were against Mittal and Sasol, where entry into those product markets, steel and polypropylene, is difficult in South Africa. And so I think that's the first point to bear in mind. An excessive pricing assessment typically is worried about whether or not a dominant firm can sustain a price above a long-run competitive price, and ordinarily wouldn't be concerned with short-run price fluctuations. So that's the first point. And I think what we're seeing here is, we're seeing here that the regulations are essentially attempting to adapt the excessive pricing framework to deal with what we expect to be a short-run problem. And I'm not sure that the adaptation can work. To Heather's point, the regulations are one part of the broader excessive pricing assessment, which must, I guess, I would expect, must still involve all the other elements listed in the Act, including dominance and others. And so I'm not sure that these regulations really do manage to make the adaptation that they appear to be seeking to make, which is to somehow discipline or deter firms from raising prices in the short run in response to a demand spike or a sudden increase in demand. That said, I think it's important for people to know that the Competition Appeal Court has discussed this idea of a prima facie case of excessive pricing, or prima facie evidence of excessive pricing. And this is more relevant now because the amended law requires complainants to make out only a prima facie case of excessive pricing before referring it to the tribunal. You know, one interpretation is that it has lowered the bar for bringing complaints to the tribunal of excessive pricing. And the Competition Appeal Court has essentially said that it may be prima facie evidence of excessive pricing when a dominant firm raises its normal price substantially without any corresponding rise in costs. And that wording echoes what we see in the regulations. So there is some basis for this in case law. And given that it is notionally easier to bring excessive pricing complaints when you only have to make out a prima facie case, I think dominant firms should take note. It's not something to simply dismiss, even if the ultimate case against them might be weak because of questions of dominance and short run versus long run and other factors. You know, being caught up in a complaint and dealing with the tribunal process, it has reputational effects and sucks up resources at a time when firms may not be able to afford them. And then the one last point I would like to make is around the idea that, well, in excessive pricing case law, the idea that a price can be above the notional long-run competitive price, as long as the relationship between the two is reasonable. So it's not automatically the case that a dominant firm is guilty of excessive pricing when its price is above the long-run competitive price. And I think that the assessment of reasonableness in this particular instance would definitely have to pay attention to the exceptional circumstances that we're in at the moment. And that should help a respondent firm, should help the case for a respondent firm rather than hurt that case.
So interesting enough, I see that one of the questions that we've had coming through is, what if the price gouging is actually not price gouging by the supplier? It's actually two customers who are trying to bid each other for supplies that they definitely want. Is that a defense, Phil, or is it a factor that one can take into account? How does it relate to this idea of the competitive price?
Is it a defense? I mean, I don't know. On a plain reading of the regulations, that would sound like, well, there's no underlying cost increase, and so that firm should be careful. But, you know, ordinarily an economics textbook would tell you that that's by costs, and one should expect. Am I still there? Can you hear me?
Yes, we can hear you again.
One should expect that
Okay, I think we have a problem from Phil's side, so we'll go back to you, Phil, once we've sorted out the connectivity issue. Maybe just to pause for a moment and just look at some of the questions that are coming from our participants, and maybe we can ask either of you, Heather or Liberty, to help us answer these. So the first question says, we compete against imports and the exchange rate has changed. Can we increase our prices to reflect the change in the exchange rate? I think maybe Liberty, this sounds more appropriate for you.
So I think the thing to note around what the Act says is that a party can defend its pricing structure. So to the extent that one is responding to an exchange rate fluctuation, that to me seems a reasonable seems to be a reasonable way to proceed. So yeah, I think there will be many firms will come across an environment where exchange rate fluctuations or even issues of servicing debt increase, or even the weakening, so all of these, even the investment implications of the downgrade, all of these may have implications on the cost structures to which a firm can use that as defense for increasing a particular price.
That's very interesting, Liberty. Thanks. My apologies. I'm also having a bit of a challenge here, but so I guess maybe the question is also around how strict the competition authorities are in terms of assessing exactly which production costs, for example, are relevant. And is there maybe a more detailed criteria that you can share with us, Liberty?
If I were to start just by reflecting back on the issue that's set up in the standards that are set up in the regulations, and just perhaps to mention that the problem is that the accusation of an excessive price relative to a benchmark has no fixed meaning in competition, and you see this. And you see this because there are so many factors that are listed in the Competition Act that may give scenarios to which a price may be above a competitive price. So if the issue, for instance, is it sensible to only stick to the standards that are set up in the regulations, my natural response would be it's not an easy answer it's not an easy question to answer, but we will see it, or we will know it when we see it. So it is possible that because of the special circumstances of the COVID-19 crisis, the standards that are set up in the regulations are appropriate. So it's appropriate to look at the increases only in production costs. The difficulty arises because the appropriate standard for excessive pricing in this current situation is being driven by rising demand and a restricted supply, or even both. So on one side, one may think of that the intensity in demand is relevant to the assessment of excessive pricing, because customers are generally willing to pay more for the features they consider valuable. Those specific features do not necessarily imply higher production costs, but they increase the economic value of the product. And as such, when this view is applied to face masks, the intrinsic value of the mask during the COVID-19 period may be higher, and people may be willing to pay more in that scenario. In normal times, however, such a price increase will tell other firms that they should produce more and where to sell. The problem now is that the COVID-19 crisis may restrict this attempt of firms that would otherwise have come into the market to discipline the actions of those that price high. And that's really because of government actions. That said, I think the price prohibition allows firms to defend the price increases if they can show that they are related to an increase in production costs, and these costs may be related to raw materials. For instance, if the index price of grain were to rise over a period due to demand, millers can implement a price increase. Similarly, if a medical supplier is suddenly forced to import products rather than purchase them locally because suppliers have run out, it can pass through these transport costs and also maybe pass through these costs to the customer. My understanding of this prohibition is that it shifts the burden to the firms alleged to be charging excessive pricing to justify why their price is appropriate in the circumstances they face. So they are allowed to come up with defenses. We've spoken about one defense in the question you've asked. So on cost increases, many firms that are currently operating in an environment where other costs, such as the weakening of the rand, the investment implications of the downgrade, all of these costs may make it sensible for a firm to raise its prices, and they may be seen as a defense for a firm to bring. And if you think about the margin, the 3-month margin period, it is not clear, that the 3 months immediately preceding the regulations are the most appropriate reference for the excessive price. I was listening to the Tiger Brand CEO yesterday when he noted that in an interview that for his business, January and February are usually the months at which demand for their products are at their lowest, and they usually offer specials and discounts during those months. So taking that into consideration, removing these discounts does not necessarily mean an excessive price. A firm could come up and justify that the removal of those discounts in relation to an increase in demand in the current COVID-19 crisis is justifiable. But also, I think there are some markets that may also have seen discipline from import competition as being lessened as a result of the COVID-19 crisis. For example, we understand that global supply chains in food have been disrupted in countries such as China and in India. They are no longer exporting key goods such as masks, sanitizers, and other food and other types of food. I know that, for instance, Russia has stopped exporting wheat. So, and then to this you add the Department of Health's new standards around safety and health, and all of this, it puts a compliance cost for importers. So I would think that such justifications can be brought in to explain why prices have increased in this period of COVID-19 crisis. But there are also demand-side factors that have also changed, that have also changed and are now different than what they would be in normal times. So the demand for some goods has increased significantly beyond what it would have been in normal times. And in normal times, firms can take cognizance of the supply and demand dynamics. So I would be thinking that a firm can use such defenses to explain why its prices are high. And then you also have an issue where some price increases will have motivations beyond beyond cost. So motivations around panic buying, where a firm may adopt a pricing mechanism that says the second good you buy will be more expensive than the first. So I think that may be a number. These are just several ways in which firms may be able to explain their high prices.
No, thanks, Liberty. Just before we go back to you, Phil, I know we had a connectivity problem earlier. I just wanted to remind the participants to keep participating in the poll, please. We've got about 76 participants on the line, but only about 70 have participated. So I just want to encourage you to continue to participate. So Phil, just going back, I mean, you were trying to answer a previous question, but there's also another question that's come up on the Q&A where somebody wanted you to repeat the name of the case that dealt with a prima facie case for excessive pricing. So if you can just continue and also just a bit more audibly refer to the case so that they can find it.
Right, so the discussion of prima facie evidence or potential evidence that might be considered to be prima facie evidence of excessive pricing is discussed in the Competition Appeal Court's decision on Mittal, which was the first big excessive pricing case in South Africa. I don't know the case number, but it's Mittal versus Harmony Gold in the Competition Appeal Court or something like that. And the appeal court, I think, quoted its own decision in Mittal in the Sasol Polymers decision as well, made the same points or similar points. I don't know if those comments in those decisions inform the amendments to the law. It's possible. But I guess the point is that, you know, we've grown up in a jurisdiction where the assessment of excessive pricing is typically enormously complex, involving volumes and volumes of economics and financial and accounting analysis and lots of numbers. But the appeal court has said, despite all of that, there may be instances where you can simply look at a price increase and say, that seems to be suspicious and may well be excessive, without doing all of those complex accounting and economics and costing exercises.
Great, thank you, Phil. There's another question, Heather, that I think will be nice for you to assist with. So somebody is asking, what is the role of the Competition Commission during this time vis-a-vis the role of the Consumer Commission? Heather, you're still on mute.
Thanks. Sorry, the Minister's regulation actually refers also to the Consumer Protection Act, which contains a restriction on unfair and unconscionable pricing. So there is definitely a role for the National Consumer Commission, and they are not burdened by the restrictions that the Competition Act imposes. For example, this requirement to define markets precisely, establish dominance, and then show that the price is unreasonably above the competitive price. None of those criteria are set out in the CPA. The word unfair would be given its normal dictionary meaning, and unconscionable seems to imply some sort of moral standard. So if you charge someone double for hand sanitizer and you don't have a good reason for doing so, a morally good reason for doing so, that seems to imply that the National Consumer Commission can step in under the CPA. The practical problem with that, however, is that the National Consumer Commission doesn't have a very strong enforcement track record. They reported to Parliament last year that they are 50% understaffed. And I think the experience of most legal advisors is that complaints under the CPA take a lot longer to be resolved if they are ever resolved. So that's a practical problem. The other issue is that the penalties under the Consumer Protection Act are not nearly as stiff as they are under the Competition Act. So under the Competition Act, you can be fined up to 10% of your turnover, even for a first-time offence, but the penalties under the CPA are much more limited. And although there are criminal penalties, those only kick in after you have failed to adhere to a compliance notice. That said, I see that the NCC has actually set up a separate hotline, and presumably they're also receiving these kinds of complaints from consumers, although we haven't had an update from the NCC yet as to what exactly is happening on their side of the fence.
That's quite interesting. I mean, here's another one, Heather, and I think I'm going to stick with you for a while. Another participant is asking, what are the rights of a supplier where consumers refuse to take a rand depreciation increase? And I mean, it's similar to what I think somebody asked earlier, but I think the nuance here is that this participant wants to engage with what their rights are as opposed to necessarily what the impact of a contravention could be, I suppose.
Yeah, so I suppose that the point to make perhaps more generally is that as suppliers and customers, your rights are generally set out. If you have a supply agreement, they are dependent on what that supply agreement says. Now, some suppliers, for example, who would experience exchange rate fluctuations or increases in raw material costs, if you, for example, use a particular chemical that's linked to an index and the index price fluctuates, you might have built into your contract this sort of event. Alternatively, some contracts have force majeure clauses that you may or may not be able to call upon. And of course, those are contractual rights that exist outside of the competition law context. But the general principle in competition law, subject to very, very few exceptions, is that there is no obligation on a supplier to supply you. So if you decide that you don't want to do business with someone because they won't pay the price that you feel is reasonable, you're under absolutely no obligation to supply them, unless, of course, there's some form of abusive dominance complaint available. So if they are an essential facility or they're providing a scarce good, then maybe you've got a complaint. But mostly pricing is determined by the normal cut and thrust of bargaining in the marketplace. And I suppose the difficulty with this COVID crisis period is that bargaining has become very intense very suddenly. And now there are suppliers and customers on each side trying to get what they need in a very short period of time at the prices that they can afford. And this is just outside of the normal experience that we have.
Yeah, no, thanks, Heather. And just maybe just going back to the issue at hand. I mean, what is the process for complaints during this national disaster, specifically, I suppose, in relation to the competition authorities?
Yeah, so the Commission has been incredibly proactive. They have indicated that they are fast-tracking complaints. They've had more than 500 of these complaints so far. They've identified that some of those complaints are not really about excessive pricing in terms of the Competition Act, but they are nonetheless prioritizing the rest. And what that means is that they're going to be sending information requests and contacting suppliers and requiring responses to these allegations on very, very short timelines. And then they are going to be referring these complaints to the tribunal on an expedited basis. And there the minister has actually put in place a set of regulations which will enable the tribunal to hear these cases on an urgent basis. And that includes requiring respondents in these complaints to file their answering affidavits within 72 hours of receiving them. And then for the Commission to respond within 24 hours, and then a hearing can be convened by Zoom or Microsoft Teams within a 48-hour period. I suppose the question that arises, however, is to what extent is it going to be possible to adjudicate on these complaints? The regulation does say the tribunal can decide on the papers, but where disputes of fact arise, as inevitably I think would do in many of these cases, parties are going to have to go back to the tribunal and try and formulate some sort of expedited process for the filing of witness statements, for example, or even for people to give oral evidence and to be cross-examined. There is, of course, provision in the regulation for the tribunal to make a pricing order and for that order to stand pending an urgent appeal to the Competition Appeal Court. But of course, that only happens once the tribunal is actually able to adjudicate on a dispute. So I think they're going to be, notwithstanding these rules, which have clearly been put in place to enable these complaints to be dealt with very expeditiously on both the Commission and the tribunal side, I think there are some real practical difficulties that flow from that, which arise because of how complex markets are and how unusual the situation is that we find ourselves in.
Yeah. Phil, can you maybe just pick up on the consumer protection side of things? I mean, from what Heather says, there's certainly a role for the consumer protection, or rather the Consumer Commission. What's your take on that, and what has been your recent experiences in this regard?
Thanks. I'm just checking. I'm not muted. Yeah, I think my feeling, my instinct is that it should be easier to deal with, I guess we could call this gouging, or the risk of price gouging during the disaster period, under consumer protection law than under excessive pricing law, for some of the reasons that I gave before and all of the reasons that Heather has provided. It just doesn't seem like excessive pricing law is the best way to try and tackle it. And in the States, in the United States of America, we know that after natural disasters like hurricanes and happening right now, at the state level, bans on gouging are implemented, and they are usually targeted at retailers. And it's not on the basis of any antitrust or competition law concerns. It's a consumer protection concern, possibly even just a political concern. State governors want to be seen to be helping those in need at the time. And so I hopped on to the CMA's website. The CMA is the UK Competition and Markets Authority. While you were talking, to see what they've done, because the CMA is a hybrid regulator, competition and consumer protection all wrapped up in one. And I was quite interested to see what they've said there. They have allowed a number of exceptions to the normal functioning of competition law, similar to the exemptions here around for banking and healthcare around horizontal agreements and cartel prohibitions. But they talk about the issue of gouging in excessive pricing language and not in consumer protection language. And they've explicitly allowed, and I think this is interesting, and it points to how they see the concern. They've allowed, under their exemptions from the normal functioning of competition law, producers or manufacturers to set maximum prices that retailers may charge for the products that they supply to retailers. And I guess that does really get to the heart of the issue, because in the very short run, the entities most able to increase prices are retailers and not producers. Retailers do it on the basis of existing stock that they have on the shelves. And so I guess the CMA in the UK said, well, one way to combat that and allow manufacturers to protect their reputation, perhaps, or act in the public interest, or help out, or be patriotic, or however you want to describe it, is to impose maximum retail prices on retailers legally, which is ordinarily not allowed. And so yeah, I'm in two minds. I mean, I think that it should be easier to do this under consumer protection law, but the way the UK seems to be thinking about it is that there is a competition law angle. That said, I don't see anything in what they have published saying that they will be looking to take on excessive pricing cases where they find instances of retailers engaging in price gouging. They may be looking to resolve these issues via other means.
So the other interesting thing is that we have got a per se restriction on minimum resale price maintenance, which is also subject to a fine. So manufacturers are not allowed to prescribe a price below which products can be resold. And then there's always been some uncertainty about when maximum resale price maintenance is and is not permissible. And in my experience, a lot of clients also will avoid that because of uncertainty about whether that will expose them to a complaint. And now any contravention of Section 5 of the Act is also punishable by a fine. So you may have manufacturers holding back on recommending resale prices or imposing resale prices which limit price gouging on their dealer networks because they themselves are worried about being the subject of a complaint to the competition authorities. So it seems to me that that's something which also should have been addressed at the same time.
Yeah, no, that's interesting, Heather. Just to go back to our Q&A, maybe this one can go to you, Phil. Someone is asking, how often can they implement price increases within one calendar year without actually contravening the excessive pricing provision? Any insights on that?
That's a very difficult question to answer. I don't think there is a simple answer. Under these regulations, I think the Commission is being quite clear that it will take a dim view of price increases that cannot be explained by cost increases. So to the extent that suppliers experience multiple cost increases during the year, they should be able to put through price increases which correspond to those cost increases. Of course, there's a question around measurement, but that's a more detailed problem. We won't get into the weeds on that. Assuming the disaster does not run for the entire year, the national disaster period, and the regulations fall away, then we're just back into normal excessive pricing territory, and there's no rules at all on price increases. Well, there are rules, but they're not sort of ex-ante prescriptive rules. The dominant firms must assess carefully the price increases that they put through in any particular calendar year for the cumulative effect, and be aware of the relationship between the new price levels and what we used to call the economic value of the goods that they are supplying, which is not easy to proxy, but is most commonly proxied by measuring the economic costs of producing those goods. So, normal compliance advice would apply when the national disaster period has passed. While it's in place, I think that there is an added risk that needs to be paid, that dominant firm should pay attention to, which is this idea that unless you can show the underlying cost increase, you should be wary of increasing your prices.
Yeah. Wow, thanks. Just, in closing, I see we're getting closer to the time where we have to finish. Maybe again to you, Phil. From an economics point of view, what would you advise as a risk mitigation factor that suppliers could take into account, or any ideas on how risk can be mitigated during this time, especially? I'm talking in terms of the suppliers not contravening the regulations or the act for that matter in relation to excessive pricing.
Yeah, again, tricky question. It depends, I suppose, on largely two things. One would be a firm's sort of appetite for risk, let's say, and how prepared it is to get caught up in a complaint process and a referral to the tribunal. And two, connected to that, how the firm sees the ultimate case against it going. I mean, we've said a lot on this webinar about how sustainable these complaints might be, given that we believe the regulations don't fundamentally alter the standard approach to assessing excessive pricing. So, it's hard to give a one-size-fits-all answer. I would say that firms who want to avoid being caught up in complaint processes should pay careful attention to the regulations and try their best to measure the relevant underlying costs and make sure that they are prepared to explain or defend or justify price increases if and when a complaint comes along. Those firms who are not so worried about being caught up in a complaint process for whatever reason, and are fairly confident that at the end of it they would not be found guilty, would not have a price control imposed, would not have a penalty imposed, maybe, taking a more relaxed view of the regulations is appropriate in those circumstances. It ultimately does boil down to the firm's views of its own risks.
And Heather, would you like to add to that? I'm sure there's something to say about legal compliance, which is meant to address the mitigation of risk.
Yeah, so I think that it's important now that there is this guide that the Minister has given us on what he regards as excessive pricing. I think you do need to have a guideline in place in your business, which at least says, if we're going to start increasing our prices in a way that isn't related to an increase in cost, or we're going to start charging a margin or markup which is above what we've charged in the preceding 3-month period, there must at least be something that can flag that is going to happen in the business. And either flag that to a senior manager or have some sort of hard stop in your pricing system which requires that to be signed off. So that at least alerts you to the fact that it's happening in the business and gives you an opportunity to decide whether to go ahead and do it or not. And then, of course, if you are going to go ahead and do it, I think there is some merit in communicating with customers. So, for example, if a retailer previously was selling pretty rose-flavored hand sanitizer at a promotional price of 20 Rand, and then all of a sudden, based on COVID, they've returned to the list price, which is 50 Rand, I think it's worthwhile trying to communicate that to customers on the basis that, unfortunately, during this period, we can no longer run specials on these items, or we are battling to source supplies and we've had to bring it in from offshore, and accordingly, our selling prices have increased. That, to some extent, may mitigate the risk that people will put in complaints because they at least understand the reason for the price increases. I see that the Commission indicates that the SPAR group has actually started giving the Commission notification of their promotional pricing over this period, and will also notify them when promotions end, so that the Commission can actually screen out SPAR-related complaints. Simply because they're no longer running a special on rice doesn't necessarily mean they're charging an excessive price for rice. And then I think documenting the reasons for price increases is important. So if the Commission does knock on your door, you should be sure that you can explain the increase in your price. And that may mean retaining quotes from suppliers or invoices from suppliers. And then lastly, if you get a complaint, there must be someone available to deal with it. You should make sure that everyone understands that they get a letter from the Commission, this must be treated seriously, and it must be referred very swiftly to senior management or your internal legal team to deal with it. Because if the Commission is going to give you 24 hours to respond and then refer a complaint, and the complaint sits on the doorstep for a week, that gives enough time for the tribunal to make a finding against you on an unopposed basis. That's what the regulation allows. And then that finding will stand until such time as you get through an urgent appeal to the appeal court, which is obviously a most undesirable state of affairs. So it is important to make sure that people are aware that these complaints are a risk and that you've got a system in place to deal with them over this period.
No, that sounds good. I wanted us to squeeze in one more question from the Q&A, and I'll direct it at you specifically, Heather. One of the participants is asking for clarity on the removal of discounts as a way to curb stockpiling by customers. Any comments on that?
Well, I suppose one man's removal of a discount is another man's excessive pricing. Once again, the reason why you're doing it seems to me to be important, and that would not be related to an increase in cost. So you're at risk unless you can justify it. And I think Liberty mentioned that one of the ways you could achieve the same thing is to have the low price on the first item, but not any items thereafter. Maybe Liberty's got other thoughts.
Liberty, any thoughts from you?
Sorry, no further thoughts on this.
Sorry? Okay.
Hi, Lebo. So sorry, you didn't hear me. I don't have any further item to add.
Right.
I think.
All right, perfect. No, thank you. I mean, we only really have a minute to wrap up. I still have to share the poll results, but I just wanted to double check with our panel members if you've got any parting shots very quickly, like 30 seconds. Nothing. All right.
No.
Thank you very much. Just going to the poll results. I mean, this has been quite interesting. Thank you very much. The poll has been closed, and we have really got nice results, which we are going to share with you. Just need to get this right. My apologies. Okay, so we have parties who are saying that they have in fact experienced excessive or unfair pricing of essential goods during the lockdown, and the answer there is at 50% in the affirmative, and then 44% say they haven't. And insofar as whether or not companies may actually have compliance policies in place, the majority of the results show that most companies have those in place. And I think the other good answer or results of the poll is that you know, it seems like a lot of the companies have actually communicated the COVID-19 related excessive pricing regulations, which we've just discussed, to their sales and marketing staff, which is absolutely excellent, because I think at this time communication in organizations is critical. And there's one question around whether business has been forced to increase its selling prices during the period of lockdown. It's a good thing to see that most of you say you actually haven't had to increase prices due to the lockdown. I think it really is a good indicator that a lot of us are doing what's right and we're following the rules. It also looks like a lot of us have got systems in place to deal with any complaints that may come from the Commission as well. So that answer has also been answered by the majority as well in the affirmative. So I think we really have a good idea of what's going on, and where people are not sure, they've at least got measures in place to ensure that they're in touch with their legal advisors or their economists in relevant instances. But I think we really are going to do well during this period. I think business, as well as everybody else, will do just fine. I think we just have to all play by the rules, essentially. Yeah, and that's it from me, really, and the panel. Thank you very much to all our participants. We really appreciate you taking time out of your schedules to be with us, and we hope that we're going to see you soon, as we hope to do maybe 1 or 2 more of these in the near future. Thank you very much. Good afternoon.